Mail and wire fraud are federal criminal offenses involving the use of the postal service or electronic communications, such as the internet, email, or telephones, to carry out a scheme to defraud others of money or property. Under 18 U.S.C. sections on 1341 and 1343, these charges often accompany other white-collar crimes and carry severe penalties, including up to 20 years in prison per violation. In the realm of federal law enforcement, mail fraud and wire fraud are among the most powerful tools available to prosecutors, because almost every modern business transaction involves some form of digital or postal communication. These statutes allow the government to cast an incredibly wide net. If you or your business are facing a federal investigation, understanding the mechanics of these charges is the first step in building a defense. While they are distinct charges, mail and wire fraud are essentially companion statutes. They are defined by the method used to facilitate a crime. Mail fraud, under Section 1341, occurs when the U.S. Postal Service or any private interstate commercial carrier, like FedEx or UPS, is used to further a fraudulent scheme. Wire fraud, under Section 1343, occurs when wire, radio, or television communication is used. In the modern era, this almost always refers to the internet, smartphones, social media, or electronic bank transfers. Federal prosecutors frequently stack mail and wire fraud charges on top of other white-collar allegations, such as healthcare fraud, securities fraud, or money laundering. The reason is simple: the jurisdictional hook. To bring a case into federal court, the government only needs to prove that you used an electronic device or the mail system at some point during the alleged scheme. Even an incidental email or a single mailed invoice can be enough to trigger a federal indictment. The penalties for federal fraud are designed to be punitive. A single count can result in imprisonment for up to 20 years in federal prison. If the fraud affects a financial institution, the sentence can jump to 30 years. There are also hefty fines. Individuals can be fined up to $250,000 per count, while corporations may face fines of $500,000 or more. Furthermore, courts typically order restitution, requiring the defendant to pay back the full amount of any perceived losses to the victims. It is important to note that these penalties apply to each individual instance of fraud. If you sent 10 fraudulent emails, you could technically be charged with 10 separate counts of wire fraud. Protecting your future. Because these statutes are so broad, they are often prone to overreach. Establishing intent to defraud is a high bar for the government, and there are many valid defenses, such as a good faith mistake or lack of knowledge, that can be used to challenge the prosecution's narrative. If you have been contacted by federal agents or have received a subpoena, do not navigate the system alone. The complexity of the federal sentencing guidelines requires a sophisticated legal strategy. Contact an experienced white-collar crime attorney today to safeguard your rights and your reputation. Call now for an initial consultation at 9252-8318-63.